Welcome back in. Although trial was put on pause temporarily, it still looks like the New York hush money case will be the first criminal trial of a former American president, especially after a few of the judge's rulings this past week. Joining me to discuss is a former Manhattan Assistant District Attorney and a current criminal defense attorney, Jeremy Saland. Jeremy, thank you so much for joining us.
My pleasure.
First question off the top. This is a straight misdemeanor case, 34 misdemeanors here in the state of New York. What's your assessment of the criminal case here put forward by the DA's office?
It's actually 34 felony charges. It's because the underlying allegation is their intent to commit another crime, another felony. So they're serious in the fact that they're felonies, they're Class E felonies. When you compare it to the January 6th case, it pales in comparison. When you compare it to what's happening in Florida or even Georgia, I think this comes at a far fourth, but let's not be silly here. Let's be honest with ourselves. A crime is a crime, a felony is a felony, and has serious ramifications across the board.
Let's get into the timing, because this case was put on pause temporarily, in part because both sides were waiting to get documents from federal prosecutors in the Southern District of New York. They got those documents, but they need some time to get through all of them in order to put up a fair case. What's your make of why SDNY would take so long to get those documents to the DA's office?
You know, I'll say generously and kindly, it's disappointing. I don't want to think in a nefarious intent here, but it's really, there's no rational reason that I can think of. You knew what was coming. You knew you had those documents. You want to err on the side of caution, and you understand whether or not they're under DA Bragg's control. New York State, under our discovery laws, are required to turn over anything we have in our control that's relevant or part of that case. So, you know, nefarious, I don't know. Is it gamesmanship? I don't know. Is it sort of that battle between the Southern District and the Manhattan District Attorney's Office? Could be, but it's disappointing, to put it nicely.
Do you think it's realistic that this case could move forward in April, especially given the judge's recent evidentiary rulings? You were in this office. You have a sense of how quickly the judges can move here, how much time they'd need to go through documents. What do you think about timing?
Yeah, I think this was a right decision initially to give some more time. That said, Donald Trump had many opportunities to confront DA Bragg about if there was missing materials, and he didn't subpoena this until January of this year. So, you know, you're going to give him some leeway, but we were giving him roughly a month, the judge said, and now we're hitting an April 15th date. Whether it commences then or shortly thereafter, that should be ample time. It sounds like a lot of documents, but 100,000 documents does not necessarily mean that they are really wading through every single piece of those papers. There could be relevant information, and there could be just a lot of extra stuff you simply don't need. So I think it can move forward in this coming month.
What do you make of the judge's evidentiary rulings that he made that seem to indicate you kind of were barreling toward an April trial date here? He decided that former fixer Michael Cohen will be able to take the stand. I don't know how much he's going to be able to say, given his former relationship as an advisor and lawyer to the president. But what do you make of some of those evidentiary rulings and what that says about the timing of trial?
Well, you know, I think Judge Merchan was very clear, and he had to parse some issues out that were quite interesting. For example, is this an advice of counsel defense or what Donald Trump called the presence of counsel defense? Can you cross-examine Michael Cohen? Of course you can, as to his credibility, but you can't bring in hearsay and say simply because there's some possible determination elsewhere he wasn't credible that he can't testify. No, that's not the case. What the judge basically did when he parsed out all these different issues, with Stormy Daniels testifying as well, is saying that you can't bring some of this evidence to show that Donald Trump has a propensity to commit certain crimes, but you can bring in some of this evidence in a more limited way to show what his intent was, what his motive was. We heard that catch and release, or catch and kill, pardon me, scheme that was alleged here. So I think Judge Merchan did a good job to giving concrete answers to move this forward.
We talked last week with our viewers about how former President Trump is trying to thread the needle here with his advice of counsel defense, right? He's saying I relied somewhat on advice of counsel, but he's not going all the way over and saying he completely relied on it, because that would, of course, open up the door to waiving privilege. Have you ever had a defendant try to thread that needle on the stand? Have you ever had to deal with this issue, or is this something that is just uniquely Trumpian?
Well, it's certainly not uniquely Trumpian. What is uniquely Trumpian, if you want to call it that, is he is trying to thread that needle. He is saying basically, I was aware and counsel was involved, but it's not advice of counsel, because if he says that, then all of a sudden that privilege that we have, like you have a privilege with a doctor that can't be released. You now have a privilege with your attorney, more importantly, but the same concept that can't be released. So what he's trying to do is say, I knew they were there. It wasn't my intent because I thought they were approving this, but not advice of counsel, because if we open up that door, it all comes out, even with or without the crime fraud exception. It could be opened up, and that's really problematic for the former president.
And just 20 seconds at the end here, you've been before a number of Manhattan juries. How do you think they're going to receive this case?
I'd like to think that all jurors are going to listen to the evidence fairly, but this isn't, a conservative Alabama jury or a conservative Georgian jury somewhere outside of Fulton County. I think they have a similar issue there.
Right.
This is probably more left-leaning, but we have to believe and want to have faith that Trump's attorneys are going to vet and remove those jurors he believes are not appropriate or are biased. So I think we'll get a fair trial. I really do.
Jeremy Saland, thank you so much for taking the time to join us.
My pleasure.